policymakers who believe that the law should be a force for protecting our democracy and improving people's lives. Some of you gathered with us just 2 months ago to discuss the somewhat unusual conclusion of the Supreme Court's last term. And as we turn toward the beginning of the term that will start on October 5th, nothing could have prepared us for the sadness that has befallen us this week. I know it's been said by others, but Justice Ruth Bader Ginsburg was more than an icon. To some in the ACS network, she was a colleague and a friend. To the broader progressive legal community and many in the American family, she was a role model and our voice. So I know it's delicate to speak of the political fight in front of us while we are still mourning her. So let me just say, in Justice Ginsburg's own words, I dissent. I dissent from the departure of norms. I dissent from the rush to nomination while she lies in state. And I dissent from the constant changing of the ground rules. We dissent. Yet even in the midst of our great sorrow, we at ACS will continue the work for justice and equality that she began, and will continue shedding light on the ways in which the cases decided by the court will affect the lives of all Americans. In that vein, let us turn today to our great program. It is my great pleasure to introduce our moderator, Kimberly Atkins, a senior opinion writer at the Boston Globe, also an MSNBC contributor. Kim was the first Washington, D.C. based news correspondent for WBUR. She has served at the Boston Herald's Washington bureau chief, guest host of C-SPAN's morning call-in show, Washington Journal, and as a Supreme Court reporter for Massachusetts Lawyers Weekly and its sister publications. Kim is a graduate of Wayne State University, Boston University School of Law, Boston University College of Communication, and the Columbia University Graduate School of Journalism. So we are most grateful that she is a repeat performer here at ACS. And with that, let me have us all join in welcoming Kimberly Atkins.
Thank you so much, Russ, and thank you for allowing me to lead this really important discussion at a really important time as we ready for the 2020 Supreme Court term. We have a fabulous panel, and I will introduce them now in alphabetical order. Nicholas Bagley is a professor of law at the University of Michigan Law School, where he teaches and writes in the area of administrative law, regulatory theory, and health law. Prior to joining the law school faculty, he was an attorney with the appellate staff in the civil division at the United States Department of Justice, where he argued dozens of cases before the U.S. Court of Appeals and acted as lead counsel in many more. Professor Bagley also served as a law clerk to Justice John Paul Stevens of the U.S. Supreme Court and to Judge David Tattle of the U.S. Court of Appeals in the D.C. Circuit. He holds a B.A. in English from Yale University and received his J.D. summa cum laude from the New York University School of Law. Also joining us today is Katherine Franke, who is the James L. Dohr Professor of Law at Columbia Law School, Director of the law school's Center for Gender and Sexuality Law, and Faculty Director of its Law, Rights, and Religion Project, a think tank that develops policy and thought leadership on the complex ways in which religious liberty rights interact with other fundamental rights. She is among the nation's leading scholars writing on law, race, religion, and religion rights, and she joined other church-state scholars to file an amicus brief in this term in the case Fulton v. City of Philadelphia, which involves the challenge to that city's requirement that private agencies who contract with the cities place foster children place foster children not discriminate based on sexual orientation. She received her JSD and LLM from Yale Law School and her JD from Northeastern University School of Law. Elbert Lynn is a partner at Hunton and Andrews Kurth and a former Solicitor General of West Virginia. He co-chairs the firm's issues and appeals practice. He's been on the front lines of many precedent-setting cases in the appellate courts across the country, and as Solicitor General, authored more than 25 briefs to the U.S. Supreme Court. He also has been a law clerk at all three levels of the federal judiciary: for Justice Clarence Thomas on the U.S. Supreme Court, for Judge William Pryor on the U.S. Court of Appeals for the 11th Circuit, and for Senior Judge Robert Keaton of the U.S. District Court for the District of Massachusetts. He is counsel of record in an amicus brief in an appeal brought by Ford Motor Company this term that raises questions about the scope of personal jurisdiction in product liability cases. Jeannie Rhee is a partner in the litigation department at Paul Weiss, and Jeannie was named the 2020 Woman Lawyer of the Year by the Women's Bar Association of the District of Columbia. From 2007 to 2019, she worked with Robert Mueller on the special counsel's office, where she led the team investigating Russian cyber, social media, and intelligence efforts to influence the 2016 presidential election. She served as Deputy Assistant Attorney General in the U.S. Department of Justice's Office of Legal Counsel between 2009 and 2011, and as an Assistant U.S. Attorney in the District of Columbia between 2000 and 2006. A graduate of Yale Law School, she clerked for Judge Stanley Sporkin in the District Court for the District of Columbia and for Judge Judith Rogers in the U.S. Court of Appeals for the D.C. Circuit. Ann Paul Smith is Vice President of Litigation and Strategy at the Campaign Legal Center and Distinguished Visitor from Practice at Georgetown University Law Center. Paul has argued before the U.S. Supreme Court 21 times, securing numerous victories, including in Lawrence v. Texas, the landmark gay rights case. He also argued a number of important voting rights cases at the Supreme Court and served as counsel for amici in several key campaign finance cases. Paul previously served as a partner in the law firm Jenner & Block, where he was chair of the firm's appellate and Supreme Court practice and co-chair of the firm's election law and redistricting practice. He serves on ACS's Board of Advisors and was previously chair of ACS's Board of Directors. Paul attended Yale Law School and then clerked for Judge James Oakes in the U.S. Court of Appeals for the Second Circuit and the Supreme Court, and for Supreme Court Justice Louis F. Powell Jr. This term, he filed an amicus brief in the case Carney v. Adams, which concerns whether Delaware can require political balance in its judiciary. And before we jump into the discussion, I just want to let the audience know, if you have a question, you can type it in the Q&A box at the bottom of your screen at any time during the program. Please don't use the chat function for questions because I won't be able to see them then. We'll get to as many questions as we can after the panel discussion at the end. Also, California CLE credit is available for this program. You can email info@acslaw.org. That is info@acslaw.org to receive your certificate and write SCOTUS preview in the subject line. If you need CLE for another state, you should see if it provides for reciprocity with California. So now that that's all out of the way, I want to jump right into this discussion, and at the top, give our panelists a moment to acknowledge, as Russ did, the passing of Justice Ruth Bader Ginsburg and her extraordinary path marking, to use a word she created, at the court. Why don't I start with you, Paul? Give us your thoughts about the justice.
Thanks, Kim. I was at the steps of the court yesterday to join the throngs of people paying their respects as she lay in repose. And it reminded me what an amazing symbol of women's equality she has become for people of all ages. It was really a remarkable scene. And I think we will not see her like again, somebody who changed the law in such fundamental ways as a lawyer and then was such a great justice and then became the symbol of such important American values of equality. It is a truly remarkable life that she lived. And I always appreciated arguing in front of her because she was always prepared, so smart, and a stickler. Sometimes she just completely took me apart. Other times she was very helpful. We didn't want to be on the wrong side of a civil procedure issue with her, that's for sure. But just one of the greats, one of the greatest Americans of the last half century or more. We'll miss her.
Jeannie, did you have thoughts about the justice?
I never had the fortune, obviously, of clerking for her, but saw her at many weddings of clerks as the officiant, for which she was known to participate and to be in attendance. Obviously, as the beneficiary, as a woman lawyer, in the steps that she blazed, it's also notable that she was a dedicated mother, a dedicated wife, a person in full in all of its dimensions, and that you can have life in the law and a personal life to boot. She's just a testament to all of the advances that we've made over the generations. And sitting here today, I'm incredibly grateful to have been the beneficiary of all of that.
Nick, how about you?
Sure. I had the good fortune to have tea with the justice in her chambers with a cake that her husband baked. I didn't know her well, but obviously she looms large in the law and in my life and the life of all the lawyers I know. I do think that she looms so large that her passing and her replacement, or likely replacement, by President Trump may refocus the public's attention on the importance and significance of the institution of the Supreme Court, and may send a strong signal about the direction that the court is going. A signal I think that most folk on this call will recognize and appreciate, but which maybe hasn't penetrated more generally. And I think we owe her that.
Elbert?
Thanks, Kim. I don't think enough can be said about the role model that she was and the paths that she blazed. But as I've thought about her since Friday, and just the good fortune that I had to meet her when I was clerking at the court, the one feature that really stands out for me personally, and I'll explain why, is her fortitude in the face of adversity. And there's a lot of obvious examples of that, going all the way back to the stories about when she was in law school and how she helped her husband, having a kid at the time, being a cancer survivor, and all of that. But the story for me that I remember is I started clerking at the court in June of 2010, the day after Marty Ginsburg passed. And if there were ever a year for Justice Ginsburg to miss a step, that would have been it. I mean, that would have been a perfectly valid year for her to not be the first to issue a written opinion, to not do the tea with the clerks, as Nick was mentioning. And Marty Ginsburg was the one who would bake for that, but she didn't miss a step. And from the outside looking in, because I wasn't in her chambers, she was as dedicated and hardworking as I think she ever was. And so part of the reason that resonates with me is because it is a sort of my experience with her. But I also experienced tremendous loss this summer in my own family, and I think about her and how she went about the really important work that she does, and she for me is a role model in that way as well.
Thank you for those thoughts. Katherine?
Thank you, Kim. I mean, to be honest, I was just devastated on Friday upon hearing of her passing. I think so many of us thought she would just live forever. She was just so tough. I certainly would, was characterized her as having fortitude, but there was some kind of superhuman qualities to her. But for those of us at Columbia, we feel like we've lost a member of our family. Justice Ginsburg went to Columbia, graduated from Columbia, joined our faculty as the first tenured woman on the faculty, brought gender justice classes and advocacy to the law school and trained what would be the next generation of lawyers working on those issues. Her daughter, Jane, is on our faculty now. And just 2 weeks ago, I was talking to Justice Ginsburg's granddaughter, Clara, about her plans to continue her grandmother's legacy, doing reproductive justice work. She's doing it now, and she will is really planning what the next generation of that work looks like. So just to reflect Jeannie's comments about Justice Ginsburg's proclivity for marrying people, two of my very close friends, Rena Rosenberg and Hassan Jabarin, were married by Justice Ginsburg. Hassan is a Palestinian citizen of Israel, and Rena is a Jewish American woman, and they could not marry in Israel because they could not have a religious wedding. And so Justice Ginsburg married them. She had such a capacious heart and knew love when she saw it. And we all miss her dearly.
And she officiated a wedding just a few weeks ago, I recall seeing in coverage. And just my own reflection, when I was a reporter covering the Supreme Court, my very first day covering an argument there, walking into that chamber alone and feeling the majesty of it, was also the day that she delivered her first bench dissent in many years, and it would become one of many, becoming the dissenter in chief, where she gave a dissent in a case on abortion rights and really underscored the importance of Roe v. Wade and Casey and her concerns about the court moving in a different direction. And regardless of how you felt on the issue, everyone in that room could sort of feel the whole place change, the atmosphere in the whole place change just in hearing her deliver. When I listened back to it, it was only a few minutes, but it seemed like it went on forever, and it was as powerful as any decision that the court issued on its merits. And to be there to see her do it in that case and in other cases involving women's pay, just to be in the room and have the pleasure for more than a decade covering her and the other justices was quite an honor for me. So let's jump into the cases that will come up this term. I want to go back to Katherine to talk about Fulton v. City of Philadelphia, which, as I pointed out earlier, is a case in which the court will decide several questions arising under the Free Exercise Clause of the First Amendment and whether to revisit its decision in Employment Division versus Smith. I will have Katherine sort of introduce the cases, and as with all the other cases, then I'll have the other panelists chime in afterwards to give their thoughts. So go ahead, Katherine. You're muted, Katherine.
Sorry. You'd think we would all learn. I still do it. Okay, so Fulton v. City of Philadelphia is scheduled for oral argument on November 4th, a week in which we may be distracted with other matters, but this is an incredibly important case. It's a case brought by the Becket Fund for Religious Liberty on behalf of a Catholic social service agency in Philadelphia. The agency has been disqualified as a public foster care contractor with the city because they will not comply with the city's non-discrimination ordinance. Specifically, they won't work with unmarried heterosexual couples or same-sex couples who want to serve as foster parents. As a matter of their Catholic principles and beliefs, they will only place children with married heterosexual parents. So Catholic Social Services is making three basic arguments. First, is that the city has acted in a way that negatively targets religious contractors such as Catholic Social Services, and thus the enforcement of the non-discrimination ordinance is neither neutral nor generally applicable. This amounts to a claim under the existing First Amendment Religious Free Exercise Clause as interpreted by the Supreme Court in the 1990 Employment Division versus Smith case. You'll recall that in that case, Justice Scalia, writing for the court, adjusted downward the protections for religious liberty under the First Amendment, holding that a burden on religious exercise could receive only rational, or would receive only rational basis review under the First Amendment if the measure that was imposing the burden on religion is otherwise generally applicable and does not target religion. Prior to Smith, the standard of protection for burdens on religious exercise was a higher form of scrutiny, even if the law was neutral and generally applicable. So Smith turned the Free Exercise Clause essentially into a prohibition against religion-based discrimination. The Masterpiece Cake Shop case decided by the court in 2018 illustrates this formulation of free exercise rights, I think, nicely. There, a baker claimed that a local human rights commission targeted him because he had a faith-based objection to baking a cake for a same-sex wedding. When government action is tainted by bias against religious exercise, a burden on religion gains heightened scrutiny, the court held in Masterpiece Cake Shop. But I will note that the court did not apply this standard in the challenges to President Trump's Muslim ban. So we don't necessarily see neutrality in the way the court protects religious liberty in across a range of faith-based traditions. So Catholic Social Services makes a similar argument to the one in Masterpiece Cake Shop in the Fulton case, that they were targeted by the city of Philadelphia precisely because they were a religious organization. For this reason, they argue the city is not enforcing the law in a way that is neutral vis-a-vis religion. Now, I'll note that this reading of the Free Exercise Clause has been pushed by conservative religious liberty advocates such as the Becket Fund, Liberty Counsel, and the Alliance Defending Freedom for at least 10 years. They've been slowly gaining acceptance of this reading of the First Amendment in lower courts, and now they have the ear of the Supreme Court. The second argument that they're making is that the law is not generally applicable. This argument has also been pushed by right-wing religious rights advocates for a number of years. And the gist of it is that if the law contains an exception, the government must grant an exemption for religious objectors, because otherwise the government is treating religious exemptions less favorably than other exempt entities that are not religious. So the radical nature of this argument should not be underemphasized, since almost every law contains exemptions or exceptions. Consider Title VII or the Fair Housing Act. There are numerous exceptions in these laws, such as for small employers or landlords. And thus, if they're exempt from the law, faith-based entities must be as well. Otherwise, the law is not generally, or because the law is not generally applicable by virtue of those exceptions. What these two arguments amount to is a flipping of the script of religious liberty cases. Justice Scalia's reading of free exercise rights in Smith clearly established a rule that unless the state was affirmatively targeting religious entities or religious exercise for negative treatment, you could not use religion as a justification for an exemption from a law that everyone else has to comply with. In essence, faith-based objections to the law receive no special protection under the First Amendment. In finding this, Justice Scalia quoted the 1879 Reynolds decision, and I quote, "To permit this would be to make the professed doctrines of religious beliefs superior to the law of the land, and in effect to permit every citizen to become a law unto himself." So what Becket, Liberty Counsel, and ADF have been pushing is an inversion of that reading of the First Amendment, that if you don't provide a faith-based objector an exemption, you are discriminating against them on the basis of their faith and are thus targeting them in violation of Employment Division versus Smith. The third thing they're arguing is something even more momentous: overrule Smith altogether and reinstall the highest level of scrutiny for free exercise cases. This too has been an agenda item of the religious right for years. Not only would they have robust statutory protections for religious exercise secured under the 1993 Religious Freedom Restoration Act, what we in the business call RFRA, but robust constitutional protections would be restored if Smith were overruled. This, of course, leads to the equally difficult question: what should be the standard adopted by the court if it overrules Smith? And about this, there is much disagreement, and the stakes are very high. They could merely say that they are restoring the pre-Smith level of protections for religious liberty and leave it to future cases to apply that rule. But it's not quite clear what that standard of protection was pre-1990. It's often referred to as strict scrutiny. That is, that any substantial burden on a sincerely held exercise of religion must be justified by a narrowly tailored application of a compelling state interest. Yet in practice, in most pre-Smith free exercise cases, they applied a kind of considered balancing between the religious liberty interest on the one hand and the government interest on the other, and when they came into conflict with one another. So there's much ambiguity about what restoration of the previous standard of protection actually entails. The court could also adopt the protections for religious liberty rights as a constitutional matter that have evolved in RFRA cases, what some of us refer to as religious liberty protections on steroids. In the RFRA cases, the court has granted much greater protection for religious liberty than the pre-Smith jurisprudence required. And indeed, in Hobby Lobby, the court held that the elaboration of RFRA rights need not be indexed to pre-Smith free exercise jurisprudence and can exceed it. Oddly enough, even though the statute says that this is exactly what the law is supposed to do, is reference the pre-Smith jurisprudence or restore it. So Fulton v. City of Philadelphia holds the potential for the court to totally revisit the nature of religious liberty protections in the Free Exercise Clause. They could do this by adopting the Becket Fund's radical reading of Smith, or they could overrule Smith altogether and adopt a much more capacious reading of the First Amendment. Amicus briefing in the case has urged limits on the reach of free exercise rights. Yes, we should protect them, but they do have limits at some point. Such as, for instance, where third parties are forced to subsidize or bear the cost of protecting another's religious beliefs. As Justice Ginsburg wrote in her dissent in Little Sisters of the Poor last term, in accommodating claims of religious freedom, this court has taken a balanced approach, one that does not allow the religious beliefs of some to overwhelm the rights and interests of others who do not share those beliefs. Holding otherwise would endorse the regulatory equivalent of taxing non-adherence to support the faithful. Such a typical, representative, powerful framing from Justice Ginsburg that she left us with in Little Sisters. By contrast, Justices Alito and Gorsuch in their concurrence in Little Sisters clearly signaled that they were ready to adopt the Becket Fund's position. Justice Kavanaugh is probably on board here as well, and a new appointment to the court before the election could well bring another vote for this position. As a general matter, let me just conclude. What I see developing is a new conservative majority on the court that is solidifying a second-class constitutional status for marriage equality rights like they have with abortion rights, such that religious objectors are entitled to ignore those second-class rights if they have a faith-based reason for doing so. In this sense, the court could be expected to further entrench a kind of tiering of constitutional rights, with some rights gaining the highest level of protection, such as religious liberty or gun rights, while others, such as privacy, sexual liberty, and equality, being no match for the weight of the court's preferred rights. Thank you.
All right, I want to give the other panelists a couple of minutes before we get to the next case, just to give any thoughts that they have on this case, on the court's increased interest for sure on cases involving religious rights and free exercise.
Look, Kim, let me just note for one thing, the Catholic Social Services Agency's claim here is slightly odd because they are serving as a government contractor, as the agent of the city of Philadelphia, and nevertheless claiming that they should be able to make their own choices about who they want to serve. And that in, I think, lots of situations would be enough to dispose of any claim. On the other hand, I think the court is very likely, as Katherine has said, to find some way to vindicate the religious freedom claim here. The push to do that is probably accelerated by the broad Bostock decision of just last June, in which the court, through the voice of Justice Gorsuch, recognized broad protections for LGBT people in the employment setting under Title VII, while recognizing that there may be lots and lots of situations in which those rights are trumped by religious freedom claims. And so I think the court will be looking for a way to do that, although I think they'll probably go for one of the narrower approaches rather than the broad, more radical approaches outlined by Katherine. It may end up looking a lot like Masterpiece Cake Shop, frankly.
Anyone else with thoughts? All right, let's move on to the next case, the Affordable Care Act challenge. I will turn to Nick to talk about California v. Texas, which is a case in which the court will decide whether the Affordable Care Act's individual mandate is unconstitutional, and if so, if it's severable from the rest of the law. Go ahead, Nick.
Yeah, thank you very much for having me here. So Justice Ginsburg's passing has focused renewed attention on this third broadside challenge to the Affordable Care Act that the court has heard since 2010 when the law was first adopted. To understand the case, it helps to take a little bit of a step back. As most of you will remember, President Trump campaigned and won on a promise to repeal the Affordable Care Act. And for much of 2017, Washington was consumed with a fractious debate within the Republican caucus about exactly what to replace it with. And when the Republican caucus was unable to come to any kind of consensus, the repeal bill collapsed and failed. Now, as a consolation prize, Republicans used their tax cut bill at the end of 2017 to repeal the individual mandate. Now, that's how both congressional Republicans and President Trump described what they did. But because the Republicans were acting via reconciliation to avoid the filibuster, Republicans didn't actually amend the substantive language of the ACA. What they did was eliminate the tax penalty for going without insurance. And by scotching the only mechanism to enforce the law, the Republicans signaled that Americans would no longer be compelled to buy insurance. Now, a bunch of red state attorneys general saw an opportunity. Now, the Supreme Court had interpreted the ACA as giving people a choice between buying insurance and paying a penalty. Now, that choice didn't matter anymore, right? Without the penalty, you could choose to buy insurance or not, sort of up to you. But when Congress eliminated the tax penalty, the red state attorneys general said, hey, if you look at the law, they left in the law this instruction that people shall buy insurance. And the attorneys general said, well, Congress must have meant by that word shall to order people, to compel people to buy insurance. Indeed, repealing the penalty on this theory made the ACA more coercive, not less coercive. And that kind of coercion exceeds Congress's power, they said, under the Commerce Clause. Now, look, the argument is preposterous, but it's not even as preposterous as the next argument in the case, which is that this $0 individual mandate is so critical to the continuing operation of the Affordable Care Act as a whole that its unconstitutionality renders invalid the entire rest of the law. Now, look, this is an argument that I think only the most dedicated movement conservative could love, and it's been derided by legal experts on both the left and the right. But the thing is that there are now a lot of dedicated movement conservatives on the federal bench. And so far, this case has met with a lot of success. A Texas district court judge and 2 judges in the Fifth Circuit have endorsed the basic theory of the case, though the Fifth Circuit sent the case back down to the lower court judge for additional proceedings on severability. So we don't have a complete resolution of the case in the lower courts yet. Now, before Justice Ginsburg's death, the odds were that the Supreme Court would not be impressed with this case. Chief Justice Roberts has twice turned away much more legally formidable challenges to the Affordable Care Act. He has an institutionalist streak, and it's hard to see how it would be good for the court to exploit a transparently thin legal argument to undo protections for people with pre-existing conditions, to kick 20 million people off insurance. And the practicalities of invalidating the ACA might give him pause. At this point, the law is very much part of the basic plumbing of the US healthcare system. So ripping it out, I mean, I don't even know where to begin, but it would cause the whole system to seize up. And there's really no guarantee in our current political climate that Congress would be able to come back into the picture and come up with a fix. With Justice Ginsburg's death, though, the Chief Justice is no longer going to be the center vote here. In this case, at least, the center vote seems likely to be Justice Kavanaugh. Now, there is reason to be hopeful that Justice Kavanaugh won't go along with plaintiffs' arguments. Kavanaugh is a standing hawk, and the plaintiffs here don't have standing to challenge a mandate that can't be enforced against them. Kavanaugh has written, including in recent years, while this case was pending, in a way that may have been a signal of the importance of salvaging as much of a congressional statute as possible, even when it contains a constitutional flaw. And finally, when the first Obamacare case came before Judge Kavanaugh, when he then sat on the DC Circuit, he didn't take the opportunity to invalidate the whole law as some of his colleagues in other courts were doing. Instead, he would have held that the court lacked jurisdiction to hear the case under the Tax Anti-Injunction Act. So he didn't have quite the same fire-breathing approach toward the ACA at the time. But here's the thing, right? I'm speculating about what Justice Kavanaugh might think about the case. And I don't know what he's gonna think. He might find the kind of wooden textualism that's at the very bottom of this case kind of appealing. And my confidence that the courts would turn away a case that I regard as legally frivolous has been shaken by the fact that each of the 3 Republican appointed judges who've heard this case have sided with the plaintiffs. So the ACA really does, again, dangle by a thread here. And I don't think the American public fully appreciates how many of the protections they've come to take for granted are at risk. I'll close by noting that if Democrats take the Senate and the White House on November 3rd, they could move after being sworn in to adopt a bill, a one-sentence bill, that would get rid of this lawsuit. It would either strike out the shall language, add a severability clause, impose a nominal tax penalty. There are lots of ways to skin this particular cat, and you could do it in a page. Doing so, though, probably would require the Democrats either to eliminate the filibuster or maybe proceed via reconciliation, although that is a little complicated too. The risk that the Supreme Court may take a swing at Obamacare, though, may counsel in favor of adopting a patch even before they act and getting rid of this case before we get a decision. But that's going to require Democrats to win big in the election. And that, at this point, is, of course, by no means assured. That's all I've got.
All right, and that's an important point that this case comes up after the election, could very well be decided after the inauguration. And so that timing is really important. But I want to open it up to the other panelists on this question, the role of Kavanaugh that Nick pointed out. And for me, I'd like to hear your thoughts about the role of the Chief Justice. I mean, he wasn't just at the center in these Obamacare challenges. He quilted together in a way by upholding Obamacare, quilted together an opinion based in this idea that if there is a constitutional way to save a statute that was duly passed by Congress, then the court should. Do you think that that will happen again?
Well, I think until last Friday, everybody who cared about the ACA was assuming that the Chief Justice would be the 5th vote to save it if no one else wanted to on the conservative side of the court. Having done it once, it would seem almost ludicrous to have thrown it out now when the mandate was rendered deliberately toothless by Congress, and Congress said we don't need it anymore, essentially. Either because you could say that it's technically invalid, but it's severable, or you could just say there's no duty left to do anything. So, but now it is at least imaginable that there could be 5 justices to the right of the chief who would still go ahead and do that. Although I think the severability argument is so powerful, it is, I think, an easy way out for the justices who don't see that there's any great point in throwing it out at this point. Maybe others disagree.
Nick, I know you, if I remember correctly, your amicus brief talked a lot about the severability point, right? And what's interesting to me is, for those of us who are Supreme Court nerds, which is basically everybody on this call, how much has been written by the court in the last 2 terms about severability, sort of whether it's fortuitously or intentionally, looking forward. And in particular, of course, the Barr versus AAPC case last year, I thought, there's a ton in there on severability. I was sort of interested in your thoughts on, I know that kind of came up in some of the reply briefing because it came out sort of in the middle of the briefing process. But I was interested in your thoughts on how, whether there's significant or useful tea leaf reading from that case or the other cases. Because it does seem as though if I remember correctly, in almost every one where they've talked about severability, the thumb has been on the scale in favor of severing, even from the conservative side.
Yeah, I think if you were reading tea leaves, that's probably the leaves that you would read. And I'll say two things, right? One is that if you have to bet, odds are, the plaintiffs have to win three very difficult arguments in order to prevail in this case. The first is standing, second is on the merits, and the third is on severability. They got to run the table. And I think they could falter at any of those stages. I do think the severability arguments are especially weak. I will say, though, as you well know, severability doctrine itself is so spongy. There is so much give in the joints that I think you can't be confident, especially in a case that starts getting the partisan juices flowing. It's not to say that the justices are going to treat this case as only a political case. They won't, but certainly the political overlay here matters. And for justices who have viewed the ACA with suspicion from the beginning, who viewed it as rammed down the throat of the American public, who thought it should have been, eliminated right at the outset, this may provide a tempting opportunity. And, I think if you were inclined to get there on severability, you could. I'll add too, the four dissenters in NFIB would have all voted to strike down the entire law, not just the individual mandate. So they've already signaled, and indeed it's a big part of the plaintiff's case, how they think about how the individual mandate, at least when it had a penalty, interacted with the rest of the law. So I guess I'd say I read those cases and I'm mildly encouraged, but I am still nervous as all get out.
I would also expect, to the extent that Chief Justice Roberts very much sees himself as the guardian of the court's legitimacy and integrity as it becomes more and more politicized, that there will be a lot of politicking within the court on his behalf to get a majority to issue an opinion that doesn't look just like a political opinion. In this and the other cases that the rest of the panel will be discussing, I know that weighs heavily on him, and he carries that weight. We've seen in a number of Little Sisters last term and many of the other cases before. I don't know whether the ACA case will be the one where he loses in that struggle, but it will surely be read as political outside the court, even if technical reasons are used to invalidate the law.
I mean, the only thing that I would just note, especially because we began this program with our observations about the most recent events and Justice Ginsburg's departure, that it's very interesting just in the landscape of the campaign that at least from one camp, there is tying of the vacancy and the political fight with respect to that vacancy and healthcare. And that insofar as there's been any express discussion about the implications of the most recent events vis-a-vis the current political calendar that we're on, that it's expressly in connection with what Nick was saying with respect to just the plumbing of the healthcare system writ large in the aftermath of the passage of Obamacare.
All right, and with that, we'll move on to another case in which law mingles with politics. It's Kearney v. Adams, and we'll turn to Paul to discuss this case in which the court will decide whether a state law that essentially limits state-level judicial service to members of the Democratic and Republican parties violate the First Amendment. Paul?
Thanks, Kim. So the Delaware Constitution, I think uniquely, has these two provisions about who can be a judge on their most important state courts. First, there was a provision which the parties have called the bare majority provision that says one political party cannot have more than a bare majority of the judges on any one court. So if there's a 7-person court, they could only have 4 Democrats or 4 Republicans. And that existed in the Constitution for a while. And then it was amended to add what the parties have called the major party provision, which says the other judges on the court have to be from the other major political party. So effectively, the combination of these two provisions means that all of the judges on the courts have to be either Democrats or Republicans. And that was challenged by a Mr. Adams plaintiff who says, I'm an independent, I'm an unaffiliated voter. I would love to be considered for a judgeship, but I can't even get to first base because I'm neither a Republican nor a Democrat. And he brought a challenge under the series of cases the court has decided over the years governing when and how politics and political affiliation can be considered in hiring people into government service. The Elrod case, the Branty versus Finkel case. In that series of cases, the court came to the view that for most routine government hiring, it's unconstitutional under the First Amendment to say that somebody has to be a Democrat, has to be a Republican, or basically to consider their politics at all because it's not relevant to government service, and you shouldn't be using the benefit of government service, of a government job, to try to force people into some political box. So that kind of patronage hiring, which was traditional in this country for many years, became unconstitutional. And what Mr. Adams says is that for these judgeships, including the most highest courts of Delaware, they should be governed by that principle, that politics is essentially irrelevant to being a good judge, and that the state of Delaware should not be able to tell me I can't serve because I'm unwilling to affiliate myself with one of the major parties. The state came back and they pointed to the so-called policymaker exception to the Elrod-Branty line of cases that says some people in government, they're government employees, but we have to be able to take into account their politics and their political affiliation. Think about the heads of departments and cabinet members of the governor in a state government. You wouldn't want to have a rule of law that says the governor who's a Democrat has to ignore the fact that he's hiring somebody who's a Republican who disagrees with his basic goals. And so there's a very strong reason why you have to have a limit on this doctrine for so-called policymakers. And the state says judges are sufficiently senior, they have sufficiently great degree of discretion, we ought to kind of wedge them into that policymaker exception. And even if the case here is strong enough to trigger heightened First Amendment scrutiny, we have some very good reasons why we want to be able to maintain this political balance requirement. Delaware thinks it's famous for having the highest quality state courts in the country, and that's in part because they've been able to maintain a political balance structure. These arguments, these defenses were not persuasive to the district court and to the Third Circuit, both of which invalidated these limitations on who can serve in judicial jobs in the state of Delaware, basically concluding that judges are not policymakers in the sense that the exception was intended to cover. They're nothing like the close cabinet members of a governor. They're simply applying the law. And there's no particularly strong interest that the state has that would satisfy heightened strict First Amendment scrutiny. So the case comes up to the court on the petition of the governor of the state of Delaware. And part of what they argue is that there's a standing problem here for Mr. Adams, at least as to the first of the two provisions, the one that caps the amount of judges that the first party can have at a bare majority. The argument is that that can't possibly hurt Mr. Adams. After all that does is leave open other judgeships that he might be able to compete for, even though he doesn't want to join the majority party. So there'll be an interesting discussion of standing in the case. It's interesting to think about why the court took this and how they'll come out on it. It's obviously not quite as important as the cases we've already discussed, but it does have some importance. I'll tell you the reason we at Campaign Legal Center decided to file an amicus brief is that we were litigating a case involving the constitutionality of the new Michigan Redistricting Commission, which has slots reserved for Republicans, for Democrats, and for independents or other parties. And the challenge was brought by the Republican Party in Michigan, saying they didn't think that those slots were either fair or otherwise constitutional. And there are actually quite a few other commissions out there, especially in the federal governmental structure, a lot of the independent commissions that have similar sort of requirements of political diversity. And so if the court is going to go ahead and affirm or partially affirm, it's important how they do this and not go so far as to prevent any effort to have political diversity in these kinds of high-level judges or other high-level positions. My own view is that they very, very well may split the difference and say you were fine when you only had the bare majority requirement. Because all that does is avoid having a political monopoly in your judgeships, and that has some value, at least appearance of some value. But then when you went ahead and cut off access to the rest of the judgeships for anybody who wasn't a member of the other party, what was the point of that, especially as it affects people who are independents or Green Party members or libertarians? How can you possibly defend an approach that says nobody but the members of those two parties can even be considered for the judgeship? And so that may very well be where they come out. And it seems like that will be a pretty good place for the court to end up, because it'll allow states to continue to mandate ideological diversity in these kinds of roles without creating any kind of duopoly just for the two parties. But we'll see.
All right, does anybody else have some quick thoughts on this case?
I apparently am obsessed with severability, but I did want to note there is a really interesting severability question here, Paul sort of alluded to, about, and it involves the interaction between standing and severability. So, in courts below, it was held that the challenger only had standing to challenge, I can't remember which it was, or I probably have it backwards, Paul, but only one of these and not the other.
Right.
And then when the Third Circuit decided that the provision that he had standing to challenge was unconstitutional, it then decided that the other provision was not severable. Of course, what's happened there is that severability has become a backdoor that's undermined the fact that he didn't have any standing to begin with. I mean, he didn't have standing to challenge the other provision, and yet he succeeded in striking it down because he had standing to challenge something else. It's a really interesting question that the court hasn't weighed in on, and it's something I thought a lot about actually in the Barr versus AAPC case last year, where the people were challenging one piece of the TCPA really so that they could try to get the whole TCPA struck down. Now, it ended up not really being relevant because they decided there was standing to challenge that one piece of it. But if they get to this, it could be an important question on severability going forward. You've actually got to show that you're injured by the provisions that you're trying to get struck down.
Right. Thanks for that clarification. And I agree with you that it's a really interesting severability argument, although I have to say, it does seem to me that it shouldn't be that tough to explain why it should be severable. The two provisions operate independently. They were enacted independently, and leaving one in place without the other certainly wouldn't make the legal structure work poorly. In fact, I think it'd make it work better, frankly. So,
yeah.
I'll add on that, Elbert, the same kind of standing severability entanglement exists in the Affordable Care Act case, because they're challenging the individual mandate, which doesn't really affect them, in order to take down the rest of the law, which certainly does. How the court's gonna think through that issue, it might be informed by this other case. And Paul, I wanted to ask you, in terms of standing, how's the court going to think through this issue? And one of the reason I'm asking is because I've seen the court move in ways. I mean, standing has been used opportunistically by the court to reach outcomes that seem congenial to it on many times in the past. Does that seem likely to you here? Does that seem like, I just love to hear your thoughts about the way that standing doctrine is evolving.
Well, I don't have any great insights into that. I think it's been an opportunistic doctrine going back to the 1970s, on the other hand, I don't really see this as a case where the court has any great ideological urge to move the law in some broad direction. So it would seem to me an easy case in which to say standing limits him to the one provision, which is the one provision that doesn't make any sense on the merits anyway, and just sort of go home. I don't know. Others may have more sophisticated views about where the court is going on standing. Clearly, standing is something they're very strict about these days, and will continue to be. I think it provides them a great deal of useful doctrine to work with when they want to use it.
Well, although I love standing discussions too, I have to be strict in this point because I want to make sure we get to our other two cases. So I'm going to throw it to Elbert to talk about a subject that I'm very nerdy about, CivPro. in discussing the Ford Motor Company case, which asks whether the arise out of or relate to requirement for a state court to exercise specific personal jurisdiction over a non-resident defendant is met when none of the defendant's forum contacts cause the plaintiff's claim. I love talking about forum contacts. Take it away, Elbert.
Thanks, Kim. This is probably the most boring case of the day, also the most technical. I'll try to explain it in as sort of plain English as I can, although it is one that Justice Ginsburg would have loved. It is right up her alley, and she actually wrote several of the really important decisions that at least are lurking in the background here. So, and it will, I think, have significant practical effect for everyday Americans, in terms of where their cases can be brought. So there's actually two cases at issue here. One comes out of the Montana Supreme Court, one comes out of the Minnesota Supreme Court. Both involve car accidents, essentially, and both involve Ford vehicles. One was an airbag that failed to deploy. The other was a tire that blew out. And what resulted from those were product liability lawsuits against Ford. And Ford moved to dismiss on the basis of lack of personal jurisdiction. So just to back up for a second, there's, of course, two types of jurisdiction that are important: subject matter jurisdiction, that the court has power over the subject, and then the subject of the suit, not the subject. And then personal jurisdiction, power over the particular defendant. And what's at issue here is a question of personal jurisdiction. And there's actually two different kinds of personal jurisdiction. There's what's called general personal jurisdiction, which is sometimes called all-purpose jurisdiction. So irrespective of what the facts of the case are, what the claims are, that there is jurisdiction over that individual or entity. The court has limited general or all-purpose jurisdiction to places where an entity is essentially at home. So if you think about a corporation like Ford, it's generally speaking in sort of 99% of cases going to be where the principal place of business or the place of incorporation is. But again, that would mean, wherever that is, that's, Detroit, Michigan, you could bring suits, against Ford there, regardless of what your particular claims are. But here we're talking, there was no general, but everybody agreed there was no all-purpose jurisdiction because Ford is not doesn't have their principal place of business or their place of incorporation in either Montana or Minnesota. So what you're left with is what's called specific personal jurisdiction, or it's called case-linked. And that means basically that you're going to have to take a look at the claims that are brought, the facts that are at issue, to figure out whether in this particular instance, power over the person, power over the entity is permissible. And so the parties basically agree that the Supreme Court precedent lays out three parts to the test. The first is, as Kim was referring to, this sort of minimum contacts issue. You have to have purposefully availed, which is the language, yourself of that jurisdiction, which essentially boils down to you got to have minimum contacts. You have to have enough contacts in that place. Here, the question would be in Montana or Minnesota, to say that you as the defendant purposefully took advantage of that jurisdiction. The second, and that's not at issue here. Purposeful availment is not at issue here. Ford has, as you might imagine, especially if you live in Montana or Minnesota, you would know that they run ads there. They've got dealerships there. They do, all that kind of. So they certainly taken advantage of the jurisdiction. There's a third prong about fair play, which is also not at issue here. What's at issue is the second prong, which is even if you have purposefully availed yourself of the jurisdiction, you have minimum contacts. There has to be a sufficient connection between those contacts and the suit and the claims. And there's a test that the Supreme Court has stated. It said it in this case, Helicopteros. So they also said it in Burger King. Great names for personal jurisdiction cases. And the test is, do the claims or does the suit arise out of or relate to the contacts that are in that jurisdiction? And that's really a question. So what does that phrase arise out of or relate to mean? Ford has taken the position, and it is the position that's accepted by the majority of federal circuit courts, but not all of them, that there's got to be some causation. There's got to be some causal link. So whatever it is that as the defendant, your contacts in that jurisdiction, so in this case, say Ford, it's got dealerships, it runs ads, it does service, those contacts have to cause in some way or give rise to the claims that we're talking about. So in this case, the accident, the particular things that happened. And they've argued that there isn't anything enough here. And the reason for that is both cars that were at issue, and again, these facts are undisputed, which makes it a nice clean case for this question. Both cars that were at issue, although generally speaking, I can't remember which specific Ford cars they are sold in the state, they are advertised and serviced in the state, but the specific cars that were at issue were not manufactured in the state, they were not designed in the states, and they were not first sold in the states. They ended up in the states because they're both older vehicles, because of a series of transactions, right, where the initial buyer bought it and sold it to somebody else, and someone independent of Ford brought the cars into the states. So Ford says there's not enough of a link because you can't say that any of our contacts in Montana or Minnesota gave rise to or caused what happened here. And they rely on two cases in particular, this Bristol-Myers Squibb case and another case, Walden. And for Bristol-Myers Squibb, they argue that, look, what the court said in that case, which involved a class action involving in-state and out-of-state defendants in California. But at any rate, the point was that the court focused on the defendant's behavior. And that's what Ford argues, is that what matters for purposes of the limits on specific personal jurisdiction are the defendant's behavior, not the behavior of some independent entities that, in this case, brought the cars into the state. And they also argue that in this case, Walden, the court said that an injury alone is not enough. So here, obviously, the injury did occur in Montana, did occur in Minnesota, but they say that the court has said the injury alone is not enough. So you put those two things together. And then the third argument they say is every case in which the Supreme Court has upheld the existence of specific personal jurisdiction, there has been this causal requirement. The plaintiff's response to this is, I sort of think, is threefold. One of them is they sort of appeal, they start really with an appeal to common sense and intuition, which is that it doesn't make a lot of sense that you would have these cases where an accident occurred in a particular state, that the defendants have cultivated a market, that's the term that they use, in that state. And so they have sort of fair notice that they've, again, taken advantage of that jurisdiction. So where you've cultivated a market and you've got an injury, and so the particular person who was hurt, in this case, or died, lives in that state, that both the state and the plaintiff have a real interest in being able to sue in that jurisdiction. And that it doesn't make a lot of sense. And in fact, there's really no benefit to Ford to, just through this technicality, have the suit be brought somewhere else. From a legal perspective, they rely very significantly on a case called Worldwide Volkswagen, which talks, then there's a line in there that talks a lot about, that supports this idea of cultivating a market, that, if in Worldwide Volkswagen, the Supreme Court had actually held that there was no specific personal jurisdiction, but it noted that Volkswagen had not sort of basically done the kinds of things that Ford has done here. And then their other argument, which will appeal to those of us who are sort of textual nerds about what words mean. They say, look, the court said it's arise out of or relate to, and that's the phrase. And that's disjunctive. And so arise out of and relate to have to mean different things, and that it's not just causal. It can't just be that the forum context give rise to the suit. There also is this relatedness standard, and that's really where they hang their hat. So that's really the clash between the two sides. If I had to predict it, I would say that if you look at the way that the court is going here, the trend is definitely in the direction of what Ford is asking for, which is that there is some causal requirement that arise out of is really the operative phrase, that relate to kind of means the same thing. And actually the court did say in a footnote in Helicopteros that it, just because it used those two, it didn't really necessarily mean, it could mean different things, but kind of left it open. So that's probably where it's going. There is a bit of a side issue here, and there's a dispute between the United States and Ford about if the court decides that a causal relationship is required, what level of causation is required. Does it have to be merely but for, or does it have to be something stricter like proximate cause? Ford has asked for proximate cause, as have many of the amici, but the United States has come in and said that proximate cause is a step too far. Proximate cause is difficult to apply. And in its reply, Ford kind of backs off of it and basically says, look, court, all you got to decide is that there's got to be a, this gives rise to requirement. Leave the rest of that debate for another day. And so with that, I will pause.
All right. And I want to keep us rolling and on time here. So if anybody has a quick question that arises out of or relates to this case, you can make it. All right. Otherwise, I'm going to move on to one of the more anticipated cases on the docket that stems from the efforts of members of Congress to obtain secret materials from the investigation by Special Counsel Robert Mueller. That's DOJ v. House Judiciary Committee. And Jeannie, I'll turn to you for that.
Thanks, Kim. So this case begins with the submission of what is now known as the Mueller Report, Volumes 1 and 2, that were submitted to the Attorney General at the end of March back in 2019. Amongst the things that were redacted in the subsequent public version of the reports that were subsequently disseminated by the Justice Department were materials that were subject to redaction pursuant to Rule 6E, which is the secrecy of grand jury materials. In Volume 1, again, according to at least the public reporting and some of the DOJ briefing, Volume 1 pertaining to the investigation with respect to Russian interference or attempts at Russian interference during the 2016 election and the links and possible coordination with the campaign during the duration of the campaign. The redactions were in the neighborhood of 240 plus. On Volume 2, which pertained to the part of the investigation with respect to potential obstruction of justice, with respect to the investigation into the underlying election interference allegations, those redactions were but a handful, somewhere in the neighborhood of 5 or so. I say all of these facts because they become relevant, I think, in what at least I would predict is going to be the way in which this unfolds before the court. In July of 2019, the House Judiciary Committee filed an application with the district court, with the chief judge, requesting 3 categories of the grand jury information material contained or related to the report. The first was the most narrow, which was just a lifting of the redactions that had been redacted for 6E. The second category was the lifting of the redactions plus the actual referred to or cited materials contained therein. And the third, which was the largest, was any and all grand jury materials that had been obtained by the investigation regarding individuals and or events that were referred to or referenced in the report. The district court in very short order issued a lengthy opinion saying that the first 2 categories were subject to disclosure, declining to allow for the release of the third upon a determination of 2 legal questions. The first, that potential impeachment proceedings, the investigation and the likelihood that there might have been a referral for impeachment constituted a judicial proceeding, which is one of the expressly enumerated exceptions to 6E's grand jury secrecy requirements. And then second, that there was a showing of particularized need for that grand jury information by the House Judiciary Committee that outweighed the need for grand jury seat protection, which is what animates that rule. On appeal to the circuit, the DC Circuit, in a split decision authored by Judge Rogers with a concurring opinion by Judge Griffith, and a partial dissent by Judge Rao, is actually a very interesting series of opinions because on the key question that is actually the single question presented to the Supreme Court for review, actually there was no disagreement amongst the three judges, two being Republican appointees, Judge Rao being a recent appointee by this administration, with Judge Rogers being a prior Clinton appointee. But the question presented is whether or not under 6E an impeachment trial is a judicial proceeding under 6E, and notably, even as to Judge Rao, she concurred in the majority opinion that it is a judicial proceeding under 6E. So with respect to the question that is now formally presented before the Supreme Court, there was no actual split of opinion in the lower court below with respect to that record. What really was the rub of contention in the DC Circuit was with respect to the second legal question that's presented, which is, okay, fine, even if it is a judicial proceeding as an express exemption under 6E, what is the required showing of particularized need, especially in light of the consideration here that separation of powers are so clearly implicated by the disputed hand? Because in order for a judicial body, a court, to review an application here about whether or not the request for the grand jury materials meets the particularized need requirement, is to invite the judiciary to essentially micromanage a dispute that involves the co-equal branches of government. And here, certainly with respect to the majority opinion, there was an understanding that because of the separation of powers implicated, the particularized need here in the context of an impeachment proceeding really amounted to a showing of relevance, and that it was related to the investigation at hand that could give rise to the articles of impeachment. And so, in fact, as noted by Judge Rao in the dissent, it's quite telling that, of course, from the time of the report submission to when the judiciary first submitted its application, a whole bunch of events overtook everyone, and that there was, in fact, a separate investigation by the same committee with respect to other allegations of election interference, this time with respect to Ukraine in the 2020 election, and a potential obstruction of justice for refusing to comply with House subpoenas in that context. What did not come out and what were not presented as an article of impeachment was the ongoing investigation into the potential obstruction with respect to the special counsel's investigation. And so here, I think the issue as it's going to be teed up for the court, again, although the formal question presented is just with respect to whether or not, as a textual matter and as a matter of historical precedent and practice, a judicial proceeding includes an impeachment trial, I think that the real heart of the matter will be a question of what does it mean to have a particularized need inquiry? What does that translate to in the separation of powers context, and exactly where is this court in particular going to draw that line, if it draws that line at all.
Okay, anybody else with some thoughts on this case? All right, well, I will get to what we have been getting audience questions throughout this, and I will start with going to some of those. I want to start the Q&A section by throwing it to Paul to speak specifically about some of the election-related cases that are heading toward the court. There are already several that are on their way, and the court could get more depending on what happens after November 3rd. Give us an overview of that.
Happy to, Kim. There is a kind of one category of case which is already heading to the court. I mean, the court's been very active on election law stuff already this term, and especially in its shadow docket, sort of shutting down some tinkering with election systems that the federal courts have been doing and the like. Then they were very involved in the Wisconsin primary, telling the federal court it couldn't delay voting until after the election day, let people mail their ballots later on. We have a case heading there right now, which is similar to that, involving Pennsylvania and whether the state courts were right to say that they would be accepting absentee ballots that would arrive after election day within a certain number of days without a postmark. Essentially, the courts below establish a conclusive presumption that if it's within like 3 days it arrives, it must have been mailed by election day, and that's okay. The Republicans are going to take that to the Supreme Court, and I think the court will hear it. And so that kind of stuff probably would continue to happen as we head toward the election, with problems with distribution of absentee ballots, overloaded systems, and efforts to try to give people more time to vote. The other kinds would come after the election, and I think we can all decide whether we think any of them is at all likely. There's obviously a lot of concern about the post-election period. But it may be that we're all basically worrying about things that aren't going to happen. One possibility would be if there was disruption of voting on a particular day, either by some malign actor shutting down the grid or eliminating registrations, or a hurricane hits somewhere. There could be lots and lots of fights about what the nature of the remedy would be for that, how broadly the revote would be, the second day of voting. That could easily end up in the Supreme Court. And then, of course, there's the one we've all been reading about and hearing about on TV for the last few days, which is the idea that there might be some effort to use legislatures to shut down the ballot counting and have people declared as the rightful electors for a given state legislatively, that rather than through the popular election, with legislatures using their power under the Constitution, under Article 2, to sort of change the method for appointing electors after the fact. That obviously could produce a ton of litigation. Indeed, the president, I think, anticipates that cases about mail ballots are going to end up in the Supreme Court. He said so himself just yesterday. And so some kind of way in which there will be fighting over the slow counting of mail ballots with potential legislative intervention to shut down the process could easily end up in the court in November/December. And then if there's ultimately a bunch of fighting at the congressional level in January about which electoral votes should be counted and which should not, there could easily be appeals to the court from that, because the statute that governs that whole process in January, is the Electoral Count Act, is so confusing and ambiguous that there might be a need for the court to resolve fights about the proper handling of the electoral votes by Congress in January. So those are the four categories. Lots to think about. Hopefully we won't have that kind of constitutional crisis this year, but we could.
Oh boy. Okay. Let's head to another question. That question, and I'll open up to the panel, which is, we've heard talk of a growing shadow docket, meaning the court is deciding a lot of cases not granted for the term and not with a full briefing and without the full transparency for the public's benefit. Please speak to that claim. And if it's true, its impact. Are we seeing this in substantive issues in law in particular? Are we hearing this in some substantive issues of law in particular? Shadow docket, anyone? It's been pretty active. Paul, I'm going
Well,
to go back to you if no
I'll
one
jump back in.
volunteers.
The one area in which the court has been very active is on election cases, picking and choosing when to intervene and when not to intervene. It's you can make various arguments about whether that's had a political tilt or not, but they have been quite willing to shut down certain kinds of decisions being made by the lower courts to change election systems in response to COVID. And they have refused in other cases. The pattern seems to be they don't like federal courts unilaterally changing the rules of the election, but if state officials are going along with it, that's okay. We were hopeful that they would intervene on the issue about the ex-felon voting in Florida. They chose not to, with a really major consequences there. So it's hard to come up with a real pattern other than they're kind of making their judgments a case at a time, but they're much, much more active than they have been in prior years on this sort of stay application part of their docket.
And is that because the Trump administration has been going to them more, or is there evidence on the other side that there's a more willingness to take a look at these sort of interlocutory requests?
Well, a lot of these haven't been coming from the Trump administration, but there have been a high number of Trump Solicitor General stay application things over the past 3.5 years, much higher than were filed in prior administrations. And they have generally been successful. And I think what Jeff Wall would tell you, the Solicitor General, is that they've had to do that because there have been so many different lawsuits attacking major policy initiatives of the Trump administration, many of them with a considerable amount of success at the lower court level. So if you're the Solicitor General, you have to basically defend your client and see what you can do. And they've found success. They haven't been turned away by the court, so they keep coming back.
Yeah, I'll add
Okay.
that I think some of the shadow docket that we're getting from the Trump administration is arising out of agency law cases where we see agencies that maybe haven't crossed their T's or dotted their I's, or who are running into a buzzsaw of politically inflected opposition in the lower courts. And, the Supreme Court tilts to the right at a time when the lower courts, at least for the first couple of years, tilted slightly to the left. No wonder that they're trying to get out from under some of the more difficult decisions that they've encountered.
Well, and I think the shadow docket may make more sense where there's a sense of urgency, like around voting or COVID. And there was one religious liberty case that was decided this way, where people of faith were trying to get an exemption from a governor's banning of mass gatherings. It was interesting to see that the court said, no, we're not going to look at that at this point. So in a context like that, where there's some urgency, I think that makes sense.
Katherine, I'm going to stick with you because we have a question about Fulton. It says, how did we get from Justice Scalia's writing Smith to the conservative wing of the court now moving towards potentially overturning it?
Well, when Smith was decided in 1990, there was a bipartisan, pretty broad consensus that it was a problem that the court had issued this decision. And I think people were also quite shocked that it was Justice Scalia that wrote the decision. And so from the ACLU to the Conference of Catholic Bishops, we had a broad consensus come together and push Congress to pass RFRA to restore on a statutory level what had been, at least in theory, what had been constitutional protections for religious liberty. And at least from the ACLU's perspective and the left, it was that religious minorities were going to suffer discrimination that could not be remedied on a constitutional level, and that was quite problematic. Interestingly, the Conference of Catholic Bishops held up passage of RFRA for 3 years because they thought left-wing people of faith would use religious liberty claims as a way to get access to abortions. It's kind of, it's flipped since then that we see really religious liberty claims being used as a way to deny access to abortions. But at the time, there was a very viable argument, I think there still is, that in certain faith traditions, the idea that your family would decide when you would have another child or if you would have a child would be something that would be protected as a matter of religious liberty law. But they finally were convinced to come along with the rest of the sort of spectrum of political positions and supported RFRA. that was understood at the time to really protect a kind of liberal value around not discriminating against minority faith traditions or people who are members of minority faith traditions. Obviously, that's changed a lot since RFRA passed, and it's really been the religious right that has made the most use of religious liberty rights since then, and particularly under RFRA, that's the case. So we're the idea of religious liberty has been captured in so many respects by the religious right. And part of what they've wanted to do is restore a constitutional, much higher level of protection for religious liberty that equals in many respects speech-based protections in the First Amendment. And so you see a lot of interesting cases where, say, a baker or a photographer who do not want to provide services to a same-sex wedding make both religious liberty and speech-based claims in their challenge to having to comply with non-discrimination laws. And they're leaning into this idea of artistic expression when they're making a cake or when they're taking photographs. And part of why the speech argument is so important is because it's a much higher level of protection under the First Amendment than the religious liberty protections would give them. I'm not sure that they would be as interested in the speech protections if we had more robust religious liberty protections. So it's just been part of a long-term conservative, mostly evangelical religious campaign to across the board use religious liberty protections as a kind of deregulatory measure. That's what Hobby Lobby was all about, to be sure. And then if they can get more protections on the constitutional level, that'd be great.
All right, I want to try to get a couple more questions in rapid fire form in just the couple moments we have left. Paul, someone asked, may a justice in Delaware change political party after joining the bench? Sort of looking for, is there a practical way around this rule?
You know, that's a question I don't know the answer to. Probably they can, and it would affect the ability of the governor then to appoint somebody else when the next slot comes open. But I don't think they would probably be taken off the court if suddenly it was a 5-2 court instead of a 4-3 court. But it's an interesting question. I guess I can't give a definitive answer.
Okay, and a question for Nick. Do you think Justice Ginsburg's absence will have a significant impact on how the court approaches the administrative state and administrative law cases? I admit I'm also an admin law nerd, so I'm interested in that answer too.
Yeah, I think the short answer is yes. I think the conservative legal movement has really focused renewed attention on challenges to the federal administrative state. And you can see this in the nomination of both Kavanaugh and Gorsuch, who had written quite eloquently about the excesses of federal agencies and about the separation of powers difficulties that arose when Congress attempted to innovate when it created new agencies. So I expect that what we might think of as an assault on the administrative state to continue. I don't think it's going to mean the end of any cabinet agency anytime soon. But I do think you're going to start to see chips get knocked in Chevron deference. I think you're going to see more hard look review. You're going to see a revival of the non-delegation doctrine, at least on the margins. You're going to see just a lot more hostility, especially if there's a Biden administration, to agency action that is designed to protect the environment, to protect workers. I think that's been a big theme in their selection process, and I suspect that the new justice will be quite happy to go along with that approach.
Elbert, what do you think?
Yeah, can I just add one quick thing? I generally agree with Nick, although I will say I think whatever shift may happen on the court is probably going to be less dramatic in this space than in others, just because I think the chief is, based on some of the things that he's written, is probably more in line with the Gorsuch-Kavanaugh view and is less likely to, from the conservative standpoint, defect than he on this issue than he might on something else.
All right, well, this has been a really great discussion. I wish we had more time, but we have run out of time. I'd like to thank ACS again for allowing me to moderate this and thank our panelists for this great discussion. And I will throw it back to Russ Feingold for some final thoughts.
Kimberly, you did a wonderful job. This is an incredible panel of people, and I think we're all privileged to hear from you. At a time when we're all feeling such trepidation about what may be happening with the court and the country, to have this kind of nuance, this kind of expertise is not only helpful, but it's actually reassuring a bit at moments. So thank you. We are lucky to have you. ACS is thrilled to be able to provide this kind of programming, and we will continue to do so. Have a good day.